morning.
Good morning.
If it may please the court, my name is Roseanne Eckert, Assistant CCRC. I'm here this morning on behalf of Joel Diaz. This morning, I would like to focus primarily on Argument 2, the deficient performance and prejudice as it relates to the imposition of the death sentence. But before I sit down, I would like to spend just a few minutes on the juror misconduct issue. This is a case where on direct appeal, 3 members of this court would have reversed due to the fact that HAC was applied by the trial court and was stricken on direct appeal. And 3 members of this court found that the state could not establish harmless error beyond a reasonable doubt. So with respect to prejudice, the jury did hear about the domestic violence and the cycle of violence that went on in the Diaz home. They heard a lot of information about the home life of Joel Diaz from the time that he was a teenager until young adulthood. What they never heard was what happened with him from birth on, that Mr. Diaz was born into a Mexican-American subculture or underclass at the border of the Rio Grande River in Texas to a very young mother. He came from a family of migrant farm workers, and he was taken to the fields at a very young age. At some point, he moved, probably around the age of 5 or 6, to the Fort Myers area. And what the jury did not hear was how his experiences from birth until the time that he was a young teenager, whether it be the exposure to poverty, his illness as a baby, the exposure to the chronic and what Professor Griffith referred to as structural violence. He was exposed to violence not just in the home, but in the neighborhood. He was bullied in the neighborhood. It was a violent neighborhood. There was testimony that he saw dead bodies in the street. I mean, this is how violent the neighborhood was. And he was exposed to violence as a preteen when he was working with his mother in the as a farm laborer, that there were adult men who were fighting, drinking, going to prostitutes. And so all of these risk factors were present for the development of cognitive. He was 24 years old.
And he had he had any history of prior violent felonies?
There were no prior violent felonies. The prior violent felony that was applied in this case was actually the contemporaneous felony, and Your Honor, in the dissenting opinion on direct appeal, recognized that under Hess that is not as significant of a prior violent felony. The trial court found no significant history of prior criminal activity, although what the jury heard was that Joel Diaz did have a history of domestic violence, that he, in fact, not only was violent toward Lissa Shaw, but he was violent toward his other girlfriends.
But what you're saying was, tell me again, what was there was a history of domestic violence in his family?
Yes.
That was not heard by the jury?
That was heard.
I'm having trouble understanding what part that would have made such a difference, to the jury. I mean, it's striking HAC. I mean, again, I said what I said in my dissent on the sentence. But what part was so that if it was discovered really would have changed the picture of the penalty phase? Because you have anyway, there's no question that this was a distraught person who was, thinking he was going to kill himself after this. He was, he waited till the police came, so the facts are the facts. what is it that you've reported that would so change the picture of the mitigation in the case? I'm still not sure I understand the additional mitigation.
The humanization of Joel Diaz in terms of the cultural relevance of his life. I mean, they saw a young man who was raised in an environment where the dad beat the mother, and Minerva Diaz testified that her father beat their mother, and her brothers beat their girlfriends, and that Joel did the same. No one, though, talked to the jury about what that really means. And as a matter of fact, Neil Potter, the state tried to get him to say, well, isn't that kind of mitigating this cycle of violence? Because it came out at the penalty phase that he had been violent, that this wasn't an isolated incident, that he had been violent. But once that came out to the jury, that he had this history of violence toward his girlfriends, they needed to talk about the cycle of violence. And you can't just do that in the vacuum. No one ever did that. The state argued in the brief that, oh, well, Dr. Keown talked about that, but that was kind of like a secret mitigation. The jury was never told in the penalty phase.
I'm hearing what you're saying, and I understand that you could put on a better case of mitigation than was put on at trial. Okay, we'll stipulate to that. But again, that's not the test that we have to look at, not whether it would be possible to find more and maybe add to what was there. The threshold question here is whether the counsel was deficient. And if we don't get past that, if we don't find that what the counsel did was so inadequate that effectively wasn't functioning as counsel should, then the rest of it becomes kind of irrelevant.
Right, and the thing is we didn't, I think that's a huge point that the trial court made. It's not just that in post-conviction we did more or better. We actually took what was there and what was in front of the trial attorneys, and they didn't bother to look at it. Dr. Crow, when he evaluated Joel Diaz, wrote in his report that Joel Diaz had a history of farm work, that he had a history of manual labor, and that his IQ was only 86. 86 is a low IQ. The jury was told that he had average intelligence. So that information was right in front of their faces. We didn't come out later and do better or more. The trial attorney didn't even have Dr. Crowell's report in his file, and his entire file's in the record. The guilt phase attorney had it, but the penalty phase attorney never even looked at that.
But it seems like what you're saying is that they should have done a better job with this. And I can, to really link in the cycle of violence. But I'm still going back to, and listen, I'm sympathetic to the situation, but still we got to follow the standards that we set forth for deficient performance. What do you point to as the most, you heard the last case where it was a state appeal, or some pretty egregious failures. What here is you look at it and say, well, any reasonable attorney would have done this.
Every lawyer is required to look at their client's life from birth until age 6, or actually from conception until age 6, because we know about how the brain develops. Dr. Dudley talked about how the brain develops. And Dr. Kling, who they had at the time of trial, said that if he had been given jail records, school records, Social Security records, if he had known, not that Joel Diaz worked as a farm, agriculture at age 16, but if he had known that he was in that environment as a toddler and that he later was there as a preteen, he would have recommended a neuropsychological evaluation. There was no neuropsychological evaluation.
Okay, and what happened? Did you have one done?
We did, and the IQ, I recognize that there were some issues with the IQ test, and I think that, his IQ is anywhere between 57 and 86. Let's assume that his IQ is 86 based on the kind of down and dirty IQ test. First, that's still a low IQ, and low IQ in and of itself is a mitigating circumstance. And it's not just that the jury didn't hear that. They heard the opposite. They heard that he's of average intelligence. Now, it's not just IQ. There's also cognitive deficits that color the frontal lobe, which is the executive functioning, that Dr. Dudley tied in. As much as the United States Supreme Court does not require a nexus between the childhood and the crime, but there was a nexus, and the jury never heard that nexus. They heard that, well, he was beaten and he committed this crime, but they never heard the entire picture.
But isn't the problem here that if he had executed the crime against his girlfriend, that, in a domestic violent way, then you talk about the cycle of violence.
Right.
But here, after he attempted to kill her, he did this thing that was really, he killed the father, and then he talked about he started acting really pretty crazy. So the early life doesn't seem to me to explain that. Did you have an expert that really explained what was going on after he tried to shoot the girlfriend?
Yes, and Dr. Dudley did both, Your Honor. Dr. Dudley talked about how the early life impact, that all of these risk factors impact the way the brain develops. So that never stopped. His brain was already developed.
But it doesn't add. You weren't going to allege the statutory mitigation. Did he?
Dr. Dudley found both statutory mitigators.
Based on, and how? Again, you can sort of say it, but
right, because it wasn't just that he was exposed, and I don't think the domestic violence was the key issue here. I think that was one part. We know that because he was exposed to this poverty, deprivation, had possibly meningitis as a child, although we weren't able to get the records, that all of this impacted it controlled how his brain developed. So now we have a little boy with cognitive deficits who didn't do well in school, who is exposed to this violence, and Dr. Dudley said there was no safe space. His mother herself was very low intelligence, really a beaten down woman who didn't teach him right from wrong. So there was no safe space. There was no loving picture. And it was a structural. It wasn't just in the home. It was the neighborhood. It was on the farm. All he ever saw was violence. And how did that impact what happened that day? Well, during those weeks prior to the incident, he was very depressed, and there were witnesses who could have talked about that.
But here's something. Prior to trial, Diaz was evaluated by 3 mental health experts. Trial counsel testified they didn't seek out additional mental health experts. There's nothing in the reports they received from the pretrial experts stood out to justify obtaining more. How does, again, in comparison, you were here for the last case, they obtained experts, they evaluated that, they don't have an obligation to keep on trying to find experts.
They didn't need more. The fact that I put on different experts, they did not need more. Dr. Kling reported sexual abuse in his report. All the trial attorney had to do was ask about it.
Are you saying that the decision was deficient in not putting one of those experts on?
They could have either put one of those experts on.
Did you put one of them on then in your evidence?
I did. I put them all. I put all of them on. The state put Dr. Cannon on. I put on Dr. Crowell, who would have testified. Now, the trial attorney said, well, he didn't. What they were looking for was this defense of insanity, and they didn't connect the two, the first part and the second part. And I think that's what this court asked. We have the prejudice because of the information that wasn't presented about the childhood, the pornography room, the sexual abuse, the low IQ, the migrant farm work, the structural violence. But we also have the failure to attack the mitigators. And they knew that they needed to deal with the CCP. And I think there's an interplay.
You mean failure to attack the aggravators?
I'm sorry. Correct. Yes, Your Honor. They didn't attack the aggravators. There's an interplay between the aggravator of CCP and the mental health mitigators, where you have this cold, calculated, premeditated intent, as this court found, transferred to Charles Shaw, coupled with his emotional disturbance and his inability to conform his conduct to the requirements of the law. They both said that they knew that CCP was an important issue, but they didn't work together. They said, well, we're gonna try to find some type of a mental health defense, and they could do insanity. That's perfectly reasonable to do an insanity defense, even though it maybe didn't really fit in this case, but only if you tie it in to the penalty phase. It's like there's a reasonable strategy to do kind of like a double penalty phase where you present a mental health defense that even though you know your client's going to be found guilty, that you're trying to either go for that second-degree murder. But the jury wasn't told the secret.
Could you explain the issue of that there were school and medical records?
Yes.
But it was in someone else's file?
Correct.
And the trial counsel never bothered to get those records?
Right.
Explain how that happened.
Ken Garber is an experienced lawyer, a public defender, I think, for 30 years, and he methodically went through and began a social history. What was in his file were school records that indicated that his client was a migrant student.
Okay, well, you're in rebuttal, so just quickly. He then was he was no longer in the case at a certain point?
Right, but what was in his, and he gave them to Discovery, but his work product he didn't copy for them. He wrote a letter.
And the lawyers never bothered to get this information?
Yes, there's testimony.
I mean, I'd start with that one, which seems pretty incredible.
There's testimony that they never went to his office. They never got copies of it. It's not just that they didn't get the school records. They didn't even, the prior attorney did get the school records and they never bothered to get it.
But he said he didn't get them because he didn't think they'd be helpful. But I'm trying to understand.
Well, under the ABA guidelines.
You're saying there's helpful information in the school records?
That he was a migrant student, which would have triggered a reasonable attorney to look into whether that impacted Joel Diaz, and that he failed 2 grades, and that he had, well, there was a poor performance. It wasn't a low IQ, but the very poor school records.
What were the IQ in the school records?
He did not have a prior IQ test.
But your IQ testing is showing what?
57, which I think is low. It might have been impacted by depression.
Isn't that the one that the trial judge refused to follow for?
Yes, for the purposes of mental retardation.
Okay, well, that's what I thought.
But
when you say you think it's low, you think it's inaccurate.
I think there was some testimony that depression may have suppressed the score. He also, Dr.
But what's the reliable IQ?
There was a prior WASI of 77 and a prior WASI of 86.
So
somewhere
that would
in
put
that
him
range.
in what?
Close to mild mental retardation range.
And they characterize him at trial as what?
Average. And he also, in the neuropsychological testing, performed in the lower 1% to 2% range on some factors that impacted his brain, his impulse control, and the crime. Before I sit down on the juror issue, I just want to say one thing. I think it's a totality of the circumstances test. The cases cited by the state and the trial court talk about kind of black letter law. The jurors would never directly ask the question, have you ever been arrested? But I think if you look under Bernal v. Lip and De La Rosa, you really look at all of the circumstances, what was being asked, and the perspective of the juror. So that's all I wanted to say about that. Here, the trial attorneys did not do a reasonable investigation. They didn't get what was in the file. They didn't do what the standards are under the ABA guidelines, which is to get the records, the birth certificates. We know that he was born at home. And so there's no strategy. We don't get to strategy when there wasn't a reasonable investigation. And with that, I will use the remaining time for rebuttal. Thank you.
May it please the Court, Assistant Attorney General Stephen Ake on behalf of the State of Florida. The trial court's order in this case is supported by competent substantial evidence that denying his claims of ineffective assistance of counsel at the guilt and penalty phases. I'd like to clarify a little bit about what counsel was ending up with talking about there, about the file and who had the information and what have you. That Kenneth Garber was the original attorney, assistant public defender. He was on the case originally. The testimony, despite the allegations in the brief that subsequent counsel never went and looked at the file, that's incorrect. Subsequent counsel Porter testified 3 or 4 times at the evidentiary hearing that he had gotten the information from Garber's file. The only exception to that is Garber's work product, his own personal notes. Were not.
Well, wait, let's go to the actual records. I thought the school records, the medical records, the records. My understanding is that he never copied those. Those weren't provided to him, and he didn't go and get them because he didn't think they'd be of any use. Was that not his testimony?
That was the other attorney's testimony, Neil Potter.
Well, did they have the school records or not?
They were not in their file. That does not mean he could not recall because it had been over 10 years, but they weren't in the file.
school records. Again, you got a 24-year-old. You got a crime that is, out of the norm, out of the norm for everybody, but, for this 24-year-old, clearly distraught about his girlfriend and setting out, he's going to kill her and then kill himself. I mean, just no question about that. You've got he doesn't get to kill the girlfriend, so he goes in the house and he does this bizarre thing, a sad, tragic thing of killing her father and then sitting there and waiting for the police. What in a defense attorney's mind would be, I need to find, just as was said, everything about this defendant from birth to 24 to understand what might have caused, because there's no issue of guilt. I mean, he's there.
Right.
This is like there's nothing to do about guilt except for try to do insanity.
Right.
To say this is a very mitigated crime. And, of course, we struck HAC, so it leaves a transferred intent CCP and the contemporaneous felony. So going back to it, what would you not do about getting school records that might show that you had a child that was marginally functioning intellectually?
Well,
just explain that to me.
What happened was, prior to trial, Diaz was examined by 3 mental health experts, and they had the reports of those experts that discussed his general intelligence as basically being normal.
And did they do IQ testing?
One of them did, Your Honor.
And what did that test show?
That was a WASI that came back with an 86.
So the 86, is that, we consider that basically normal?
I think that's very indicative of his scores. There was testimony that he took, the school records showed that he took this California achievement test in his elementary years from kindergarten through 5th grade or what have you. And those correlated to an IQ of like 91 up to 114. So the testimony at the evidentiary hearing from the state's expert was that there was normal academic functioning in this case, that he was capable of...
Did he fail 2 grades or not?
Yes, and according to him,
but
it was
all we're first talking, we're not talking about yet prejudice.
Right.
I'm just asking,
Right.
Because one of the things throughout the time I've been here is that I never, and I think the ABA says it, you start with records. You can
Right.
get experts to say, unfortunately or fortunately, just about anything. But you start with the records because sometimes the records reveal things that lead you then on the path. And for a defense lawyer to say either, I didn't think they would be helpful, is when they're already in someone's file, I don't get that. And
Right.
you're saying they might have had them, but they didn't use them and they're not in the file. So I thought that the evidence was that he didn't think they were important to obtain. Is that true or not true?
That was Neil Potter's testimony. He was primarily responsible for the penalty phase. Unfortunately...
So so then that is what happened. They didn't obtain these records that were clearly in the prior defense lawyer's file. And there is information in these records that may have been helpful to use in strategizing on how you're going to present mitigation.
Well, they may have been, but I would argue that there was no prejudice, even if
well,
they
now,
had
as I said, we
right.
start with one or the other,
Right.
but you were starting with no deficiency.
Well,
and
I was trying to clarify the file situation because Neil Potter did testify about that. He was primarily the penalty phase. The guilt phase attorney, Porter, testified in detail about this at the evidentiary hearing. Neil Potter never really testified much. All his testimony was, I can't recall if I talked to Garber.
But this is all this not recalling stuff, which I understand happens, but when the penalty phase lawyer, who's responsible for it, says, I didn't get it because I didn't think it was important, and the guilt phase lawyer, we're supposed to have 2 lawyers in there, so you have a coordinated
Right.
conduct, okay? It says, let's look at the school records. And the other part, I do not understand, and explain it to me, how when you have you mounted an insanity defense, did they mount an insanity?
Yes.
Okay, because that's the only defense.
Right.
Then were they carrying over whatever was the failed insanity defense into
the penalty phase.
The penalty phase. So what was put on by them in the penalty phase.
The only live testimony at the penalty phase was the sister and Joel Diaz himself. And
Now,
they relied on the guilt phase because they had actually introduced the reports from Dr. Kling and the state's expert, Dr. Keown, in evidence at the guilt phase.
And I guess my problem with that is that, again, you've got a situation, you failed on showing he's insane, and that was what you were saying. So the issue for insanity is very different than the issue for mental health mitigation. What was their reasoning? Well, after they lost on insanity, they know they've conceded guilt, essentially, by saying that's what you have to do, right, for insanity, that he did it, but he wasn't capable. Right. So it's not a question of, listen, this guy did it. Now we have to examine what would make a distraught boyfriend try to kill his girlfriend and then kill the father. So how do you not put on credible mental health testimony? Where's the downside on it?
Well, Your Honor, they did present it at the guilt phase, but they didn't recall him at the penalty phase.
But that's what I'm saying to you. When you present it in the guilt phase, though, you're presenting it for a different reason. Well, I understand they said that. Was their reason that we thought they would remember what was in the guilt? Is that what they said?
No, Your Honor. What they said was twofold. One is that their client didn't really like that kind of evidence presented, and he was hampering their he didn't want that presented. He didn't want them investigating that aspect. And the other thing was they had the reports. There just wasn't that much in them to present. Basically, the report shows that he has anger issues and he was depressed, and that's pretty much the gist of all the mental mitigation in this case, is that he has severe anger issues, and that was presented to the jury.
How do you think? You don't think that a history of from the point of when he was born up until his life there, that what was reported or recorded by Miss Eckert in her argument might be very powerful?
No, that would not have gone over well with the jury, Your Honor, because it wasn't actually factually correct, first of all. He was not a migrant farm worker's child. He grew up in the city of Fort Myers in a residential area. He lived in low-income housing projects at some point in time, but he also lived in a home. But the testimony is very vague as to what he did himself. I will grant that his mother was apparently a migrant farm worker from Texas, and that they moved here when Diaz was about 5.
Was there violence in the house?
Yes, and that was presented.
That he witnessed?
Yes.
That was presented through the
sister.
Okay, but don't you need an expert to explain how the cycle of violence influences a child as they become an adult in terms of how they deal with relationships?
Right. Well, some of that did come out in the guilt phase, Your Honor, and it was certainly in the report. So the jury was aware of that.
Do you think that having it in a report, that then the jury is just going to know to read the report and make their decision on mitigation?
It's presented there for their availability, but it was presented at the guilt phase. That was their whole, that he grew up in this violence and that he had this anger issue.
But there was you're saying there was expert testimony,
right,
concerning that. So it's not just in the report, but the expert is actually testifying about that, and that's being presented in live expert testimony to the jury.
Correct, Your Honor. That came out at the guilt phase. And
I guess the problem is when the jury has rejected insanity, to decide then to say, well, even though you didn't believe him on this, let's re-explain this. I just think is difficult.
Now,
whether it's
I think it would just simply be cumulative to what they testified in the guilt phase. It might be a little more detailed or tailored.
When did this penalty phase start?
The trial was in the very end of July, last week, I believe, in July, and the penalty phase was, I think, the first week of October.
So you...
August,
I don't
September.
Remember what happened last night.
Yeah.
You're telling me that the jury was going to just go on about its business, and by October would say that, sure, they remember exactly what the testimony was?
That was the whole defense at trial, Your Honor. I'm sure they had to remember that when that was the only thing that the defense presented at trial.
Tell us how the defense actually argued in the penalty phase, the mitigating.
Well, they attacked the aggravators, and then
I'm sorry. They did what?
They attacked the aggravating circumstances and spent time on that, and then they discussed the mitigation from the sister and the mental health.
I guess the real question, though, is did they discuss, if they were relying on the information that was presented in the guilt phase about mental health, did they re-argue in the penalty phase the evidence that was actually presented?
My recollection is they did. They were seeking the statutory mental mitigators. In fact, they got one of those from the trial judge, actually found one of the mental mitigators and found the second one without the adjective of substantial. Found that his ability was impaired, but not substantially impaired. So you're telling us that they did, in fact, argue in the penalty phase what was actually presented? Your Honor, I don't have a specific recollection. I didn't review that part of it right before I came here, and I don't remember exactly what they said on that. I remember reviewing my notes that they had, addressed the aggravators and addressed the sister's testimony, but I don't remember exactly what they said. I couldn't tell you. I'd have to go back and look at that.
And to what extent did the sister's testimony actually talk about their life growing up?
She talked about that they were raised in the low-income housing projects that he quit school at 9 years old, after ninth grade, that he quit school to go to work because they were low income and that the father was abusive and they had to support the family by going to work. And I would add that by going to work, Diaz went to work as a busboy at restaurants and various things like that, and eventually ended up at a lumber company. This was not migrant farm work that he was doing. Again, the testimony was that he did, I think, a week one time at 12 years old in farm work, and then pretty much the remainder of his work history was all...
Well, as I understood, part of their argument is that he spent a lot of time in the fields, and that he was subject to a lot of pesticides and herbicides and those kinds of things. And so what do we have in the record that supports that he had this kind of exposure?
There was testimony that they brought in from a social worker and from a professor regarding the whole culture of migrant farm workers, and they talked about various vague interviewing things. But what came out of that was that Joel Diaz reported one time being sprayed with a pesticide. The evidence showed that he apparently had accompanied his mother at various points in time as a 10 to 12-year-old child in the field. But the Social Security records, the income records, showed that he had only received, I think it was $300 in pay as a 12-year-old for working in Quincy, Florida at a packing house or something of that nature. There just simply wasn't that much. They try to paint the picture that Diaz is living out on a migrant farm, and that's not the case. He was living in the city of Fort Myers in a residential area from age kindergarten, 5 years old, all the way through. His work history, mainly as a young adolescent up till the time of the crime, was all restaurant-type work or working for the lumber yard, where he had worked for, I think, 4 years prior to the crime.
Remind me of what's the time frame between the time the victim that was shot?
Right.
What was the time frame when they stopped living together? She moved it back in with the time.
It was, I believe, 8 or 9 months that they had been broken up. They hadn't even spoken for at least a month, I think, before. But I think it was 8 to 9 months breakup before the murder actually took place.
So, and what was going on during that time period?
Not much. He was texting her, trying to reestablish contact with her, and she didn't want to engage in that and wouldn't return his text and that kind of nature of it. But like I said, it had been a month before they had any contact prior to the actual murder. And they had lived together for, I believe, I think they dated for 2 years and lived together for a year. And she had testified pretty extensively as to the whole adaptive functioning and the mental retardation claims. So
I guess I thought I remembered something about various contacts between them from that time where he tried to assault her in a parking lot or something.
Right.
And,
there were incidences.
So there was some kind of contact between them of a violent nature, I assume, between the time that they broke up and the time of the murder.
Right. There was this Western Auto incident where the victim, I believe, he approached her and tried to kidnap her and beat her or what have you, and that she filed a restraining order against him. But that was months before, if my recollection is correct.
Okay, and my final question is, what is the state of the record about any kind of mental health counseling or anything about this?
I don't believe he ever had any. I don't believe that there were no experiences with any kind of mental health practitioners prior to them being appointed in this cases. I don't believe he had ever. I think the experts asked him that, and he said he had never seen those, or never seen a psychiatrist or any kind of mental health expert. I wanted to basically briefly go over the file thing with Dr. Krause's report. She indicates that it wasn't in his file, but I would point out that it was actually mailed to Frank Porter. So I'm just troubled by this court finding that things that weren't in their file and that they couldn't recall showed deficient performance. And I want to stress that basically it was over 10 years, or about 10 years, I think it was, from the time of the trial till the time of the evidentiary hearing, and counsel had a difficult time recalling what all he had done.
I mean, but it's clear that these records were not in their files.
Right.
And whether one attorney says he actually had them and saw them,
right,
that could or couldn't, may or may not be the case, but we do know they were not in the file.
Right.
I just is there any indication that anything that was in these records was actually used during either the guilt phase or the penalty phase of the trial?
Well, as I said, the two experts' reports were actually introduced into evidence. The third one was not. Dr. Krause's report was never introduced, and it's a much briefer report. I think it's only 2.5 pages long. But the other two were admitted into evidence, one by the state and one by the defense.
And they show that they reviewed the school records?
No, they do not.
Well, I thought that was...
The testimony was that he basically had done average in school, which was accurate when he put forth an effort, apparently. But
based on, but would they? Again, this shouldn't be that hard. Would they? If a child drops out in 9th grade and he's failed 2 years, that's not doing average in school.
Well, he testified that he failed the kindergarten and 2nd grade because language. He grew up in a Spanish-speaking home and then moved into an English language classes, but his grades reflected.
He testified when about that?
Well, he didn't. I didn't mean to testify. He told that to Dr. Gamache in his interview, and that was videotaped.
What do the records show about why he failed those grades?
Well, I think that's probably accurate based on the school record. I don't think his.
You failed kindergarten because
he couldn't speak English. The school records show that he was more than capable of making average grades. Whether, as Dr. Gamache said, they don't show any indication of intellectual impairment.
So he only dropped out of school so
to
he
go to
could
work.
help
Yeah.
his mother.
Right. He wanted to go to work to support the family.
At what age was that?
It was when he was in 9th grade, and he was older than your average student. I don't remember. I think 14 or 15. I'm not sure.
Briefly, if he failed 2 grades, it seems to me he would be, 15 or 16?
That may be.
17 at that point.
I think it was 15, but I'm not 100% on that. For some reason, that sticks out because I believe he started working as a bus boy at 15 or 16 at a Perkins, and I think that's when he had quit school. I wanted to very briefly, talk about the juror issue. The juror never gave any false answers in this case. She was never asked. What was the
actual state of the juror? Was had been arrested?
She had been arrested for domestic violence and completed a pretrial intervention program prior to jury selection. She was never asked had she ever been arrested. The jurors were asked if family members or close friends had ever been arrested, and all of them responded appropriately as to that. Only one juror relayed his own personal experience with the law in front of the entire veneer. So I don't even think it's reasonable that you can say that, the jurors were on notice.
And this person actually served on the jury?
Yes, she was the foreperson. Yes. I would ask this court to affirm the trial court's order denying post-conviction relief. Thank you.
Justice Quince, Mr. Diaz and Mrs. Shaw lived together until August of 1997 when they broke up, and this crime occurred in the end of October. There was evidence that was presented that was in the report that there was a restraining order that was obtained, even though everyone agreed that
there was evidence that
she tried to get a restraining order against him. That was entered into evidence in the report.
And when was that restraining order?
It was never served on him, but it was a result of a violent incident. And
if they went ahead and they have all this mental health information in the guilt phase, why is that not reasonable then to refer to it and argue it in the penalty phase?
Because they didn't argue it. And Justice Quince was asking about what Neil Potter argued. I set forth what he talked about on that issue on pages 22 and 23 of my reply brief. I just put the whole transcript. He mentioned Dr. Kling one time. At the beginning, he said, I want you to find the statutory mental health mitigators, but he never said, take a look at those reports that are in evidence. He never suggested it. So this idea that they were entered into evidence strategically is just not true. It was like secret mitigation. They weren't even published.
Were they a part of the penalty phase also?
Absolutely not. They were never mentioned one time.
Did the experts testify during the guilt phase?
During the guilt phase, Dr. Keown testified and Dr. Kling testified. But Dr. Kling
were those the reports that you're referring to?
Those reports were then entered into evidence during the guilt phase.
After the people had testified?
Correct.
Did they testify fully, or did they just say their names?
They did not testify fully. Dr. Kling talked about the weeks leading up to the crime with respect to the insanity, but there was no discussion in the guilt phase by Dr. Kling about the family violence, the sexual abuse that he found. No one ever asked him about the sexual abuse, and that wasn't strategic.
No, well, that would have been because that really doesn't have anything to do with the insanity.
Right, which is why you need to focus on it, even if you're just relying on these reports. And Dr. Kling was kind of destroyed in the guilt phase. That's when you go to Dr. Crow. In Dr. Crow's report.
Destroyed in what way?
That the prosecutor was able to show how many of the facts he didn't know, and they rejected the insanity defense. And the trial prosecutor was able to establish that he really didn't know many of the facts that he should have known. And so I think the jury would reject his testimony.
Are we talking about many of the facts about the crime?
The crime.
Which would have demonstrated whether he was insane at the
Correct.
time of committing the offense versus many facts about his life and that kind of thing.
Right. And then Dr. Crow never testified, and his report was never entered into evidence. It was in one attorney's file, but it never made it to the other attorney's file. And they said they didn't know about the low IQ.
I'm looking here at what you actually quote in your brief, and he does make reference to Dr. Kling's testimony.
About the mental infirmity. That's it. He doesn't say take a look at that report where he talks about the sexual abuse. He never asked.
Well, he says, that he was suffering from mental infirmity. Once you got, as you consider what Dr. Kling had to say. I mean, so he's referring them back to that.
In the guilt phase, he didn't say look at the reports. He never said look at Dr. Keown's report, take a look at Dr. Kling's report, and they weren't published to the jury. So the jury would have had to affirmatively say, we want to take a look at those reports.
They'd have to go and find the exhibits from the guilt phase.
Correct.
Look at a report.
On their own.
After how many months between?
Exactly. Right. And so this is kind of like an after-the-fact strategy. It certainly wasn't strategy to say, well, we're going to rely on reports.
What did the trial judge, as I understand it, the trial judge actually found both statutory mental mitigators, right. And what were those based on?
I don't really know. I know that Dr. Kling only found one of them, and the trial judge actually found both. And I think under Porter, it's clear that even if the trial judge found these mitigators, the issue is that the jury, we don't have any idea what the jury heard.
But you have no idea what the trial judge based it on?
No, it's not actually clear. It's almost like they were based on the same evidence is what he found it on, based on the same testimony by Dr. Kling in the guilt phase. But the trial attorney the trial judge is sophisticated. He knows he can look at the guilt phase testimony. The jury was never really told that.
Was there a Spencer hearing?
There was a Spencer hearing.
Did they argue the reports in the Spencer hearing?
No, they did not. The issue primarily in the Spencer hearing was the CCP. And the attorney, Mr. Diaz, did say he did not want his mother to testify at the Spencer hearing, but that has nothing to do with failure to investigate. Minerva and her mother went and talked to Dr. Kling, but that information wasn't followed up on. Joel Diaz, it's just not a fact that Joel Diaz did not want to cooperate. It's not true. After the penalty phase, he was upset about some of the information that came out. It has nothing to do with why there wasn't an investigation in this case.
Thank you for your arguments. The court will now take a 10-minute recess.
Thank you.
All rise.